That wasn't
We're for a
granted.
decision at 11 on Sunday, and that will be the final decision of this court.
But GECOM has already taken a decision to facilitate a recount from 1 to 10.
Yeah, but I don't think the mechanics of that can start right away. I mean, they're going to have to sort out containers where they do it, tell personnel. So I don't think that's an immediate
Thank
factor.
you.
Thank you.
Kim Kite, any comments? Any comment? I know the question of GECOM facilitating a recount was brought up in the court.
Yes, but the execution of that process will not commence before Sunday, so that neither party has anything to be fearful about in respect to any prejudice.
Okay.
All right?
But a decision was taken though.
Yes. Well, that is what I was informed by the rest of us. Okay.
Thank you.
Can you keep them here?
No problem. I was running.
She was
behind
walking.
Mr. Nanlal, I know for the starting off the hearing, a request or application was made to in effect stay the proceedings of the court pending the final determination. But GECOM hasn't spoken. Could you brief us on that?
An application was made by Mr. Ford for injunctions or some sort of order to be granted by the court to prevent GECOM from going ahead to make a decision on the question of recount. As I indicated to you yesterday, no application in writing was made, and no application the court didn't have anything before it of any substance to adjudicate on such an application. More fundamentally, however, an application can only be made to an appellate court once there is a cause pending in the court, meaning that there must be an appeal at least pending. You know that in this case we are dealing with an application to appeal or leave to appeal, and the appeal, where if leave is going to be granted, then we will hear the appeal at the same time. The application for leave was not granted. So when Mr. Ford made that order, made that application, there was nothing pending before the court. An interlocutory application can only be made in a pending cause, so there was no really pending cause. And as I said before, there was no application in writing before the court, and none prevented Mr. Ford, nothing prevented Mr. Ford from making such an application before, long before. So we objected, obviously, and we pointed out to the court that we will have to be heard before any such application can be made, because an appeal by itself, even if one was filed, doesn't operate as a stay. An appeal only operates, deals with the appeal itself. And since no application for a stay was granted, it's not automatic. A case has to be made out for those kind of interlocutory orders to be granted. So that was rejected, and the court proceeded to hear all the legal submissions orally. Of course, we would have submitted in writing copious submissions overnight as ordered by the court, and the court indicated to us since yesterday that we would be required to highlight certain issues orally, and we were led by, our side was led by Mr. Mendez, and their side was led by Mr. Scotland and Dr. Francis Alexis. And we concluded today, and the court has fixed 11 o'clock Sunday to give its ruling. I want to take this opportunity to welcome the decision made by GECOM to proceed with the recount, because that's the direction where we have to go, and that's the direction that the law says we must go.
All right, thank you. The Court of Appeal, do you think that was explained properly?
No. It wasn't explained properly because there's no explanation that Mr. Mendez and the other members of his team could have put forward. There's no provision in the Constitution, there's no system of law, as I know it in this country, which specifically confers the right of an appeal in relation to an interlocutory matter on a constitutional issue. So my learned friend Mr. Jonas is indicating that we should fall back to all different provisions that does not deal with the issue of an interlocutory appeal in a constitutional matter.
I know my colleague asked you about the application this morning and GECOM's decision just a few moments ago about the recount, but what stops them from going ahead and putting steps in place for a recount, even though they may not start a recount?
No, that is not the concern that we have.
Okay.
The concern that we have is them indicating and actually exercising and doing a recount. That is the concern that we have.
Okay. Thank you. I just want you to know your mom just said to put your mask on.